the President's authority to establish those tribunals in the first place, and then over their lawfulness at all. In cases that, before, say, 2002, would not even have been litigated in federal court. There was a case law in place at that time that said that such cases could not even be brought. They were litigated, they were brought, and the Supreme Court held that even the authorization for the use of force after September 11, 2001, and the Detainee Treatment Act, with Congress at least implicitly recognizing authority to try war crimes before military tribunals, were not specific enough. And so Congress obligingly passed the Military Commissions Act, which, as its name suggests, unmistakably authorized trials before military commissions. As I said, the procedure was in place, all was in readiness. In fact, the trials were supposed to start when we were told a week ago Friday. That's significant. Somehow lots of things people think in Washington aren't going to go down very well. They're announced on Friday. There is a myth about that nobody reads the Saturday papers, and so all the news get announced on Friday. There was an announcement on Friday that the Attorney General had decided on his own authority. He said that he was going to bring Khalid Sheikh Mohammed, who was the self-proclaimed mastermind of the September 11, 2001 atrocity, and then also, by his own boast and by videotaped evidence, was the person who beheaded Wall Street Journal reporter named Daniel Pearl, to bring him, Ramzi bin al-Sheikh, and a number of others. Ramzi bin al-Sheikh had been the director of operations on 9/11, and others involved in planning and carrying that out to the United States for trial in a civilian court. As I mentioned, trials were about to be held for these men for war crimes in the military tribunal, where they would have had counsel cleared to see and handle classified and other confidential information, where a courtroom had been constructed unlike any other, certainly any in the United States, with technology specifically directed at handling classified documents and information, transferred from any point on the globe in such a way as to make its presentation possible, and yet to allow security to be maintained. The detention facility at Guantanamo, which I visited, I will tell you, compares favorably with medium security prisons in the United States. We have maximum security. It compares favorably with medium security facilities in this country, principally because it's remote and inherently secure, and thus there's no need for the kind of restrictive conditions on the kinds of prisoners that we have in this case, who would be housed in maximum security facilities in the United States. In fact, during my visit in Guantanamo Bay, I was able to see what are referred to as the high-value detainees, who were under a dozen of them, who were under 24-hour video surveillance. Unfortunately, I was not able to see Khalid Sheikh Mohammed. He was out visiting with a visiting delegation of the International Committee of the Red Cross, complaining about this, that, and the other. But I was able to see his cell, and to my surprise and somewhat my consternation, I found that he had available to him the same make and model elliptical machine that I had available to me at the residence I stayed at in Washington, except I had to wait my turn. Jim, he had none. I doubt he's going to have it that good when I ask him if he gets to the United States, and I'm sure there will be lawsuits addressed to his prison conditions once he enters this country, because the courts will be open to him once he enters this country in a way that they are not open to him from Guantanamo. Some of you may recall that Khalid Sheikh Mohammed said on more than one occasion when he appeared before the military commission that was to try him that he wanted to plead guilty, and it's been suggested that in a civilian court the trial might not take that long because if he's inclined to plead guilty, that part of it will be over. In fact, the Attorney General suggested as much as suggested this week. Two responses to that. First, his initial response when he was first captured was, "I'll see you with my lawyer in New York." This is someone who intends to and will use the system in any way that he can to create as large a spectacle as he can, whatever system he's in. The military commissions regimen did not allow for the kind of free access that is often possible to carry on in a civilian court. And so I would suggest to you that it takes plead guilty will become inoperative once he hits an American
He's
court.
going to change his mind. He's going to change his plea.
He has not entered his plea.
Oh.
Indeed, the charge has not yet been filed. I won't get to that in a minute, but in the military commission that he appeared in, he said, I want to plead guilty, and I will face whatever execution is time for me. He now has a different and far bigger stage, and there's no reason to believe he'll refrain from using it, particularly when one benefit might very well be access to classified information that has to be disclosed, needs disclosure, kind of discovery that takes place in civilian trials, whether it comes tumbling out in court as part of the government's direct proof, or as part of the defendant's examination of witnesses, in order either to find out that kind of evidence or to make it appear to a jury that the government is being invasive and has something behind. The argument has been made, and it was made indeed by the Attorney General's testimony, that the Classified Information Procedures Act, acronym CIPA, that applies to civilian courts, would allow the government to protect classified information by providing summaries and the like, along with the claim that no ground is lost here because the procedures in military tribunals are, as the Attorney General put it, based on CIPA. Several problems with those arguments. First, I'm sure when you go to see a movie that is based on a book, you know that you're not getting the book. There are numerous differences between CIPA and the rules that prevail in military commissions. First, CIPA was written for very different circumstances from the ones that face us here. It was enacted in 1980 to combat the threat of what was then called gray mail in espionage prosecutions, where defendants essentially threatened to disclose classified information in open court and thereby make their prosecutions impossible. And the response to that was a statute that permitted for summaries of classified information so that that trap could be avoided. It provides no ability by a judge to evaluate methods and reliability of gathering classified information independently or ex parte, that is, in private. The statute wasn't made for that. And even if a judge were to attempt to do it, and bend the statute to fit that necessity, under the rules in criminal cases, the defendant is entitled to a relevant evidence defense, and if he chooses to represent himself, and that is included in the constitutional rights of counsel. The constitutional rights of counsel does not obligate a defendant to take a lawyer. It guarantees the defendant constitutionally the right to the defendant chooses to represent himself. That's a constitutional right he has, and of course he would have access to the same information that a lawyer might have access to if he were represented by counsel. That kind of procedure would not apply in a military commission. It will necessarily apply in a civilian case. As I said, it provides a mechanism for a judge to make an independent party assessment of the reliability of intelligence sources and the methods that underlie the gathering of classified evidence. And the presumption, even as classified evidence,